The judicial institution, as well as the judges within it, must be free among themselves to make their own decisions based solely on the facts and the law without any other considerations. Apart from the managerial functions, the 4 senior-most judges cannot and do not interfere with the decision-making process of any other judge. If the judiciary has been remarked or observed as being independent, then perhaps, as an institution, we have worked hard to be internally independent, not only in fact, but also in perception. That leaves us with the second and no less integral of its facets, external judicial independence. This category is limitless because it deals with external pressures and influences that can directly impact the judiciary's actual ability or perceived ability to decide cases. Certain non-exhaustive examples include, first, intimidation of judges, either in the form of threats, physical harm, lies, or even public humiliation by, for example, attacking the personal reputation of certain judges or their family members. Second, attempting to seek favor with judges or contacting them directly or indirectly to decide cases in a certain party's favor or against another party. And third, manipulative media reports that unfairly paints the impression of a decision meaning more or less than what it actually is. Those are just some examples of acts that are sometimes intentionally, either directly or indirectly employed with a view to swaying the course of justice in a certain direction. These are just a fraction of available examples from a bottomless list of anything that can effectively amount to external judicial interference affecting external judicial independence. The judiciary has little to no control over external judicial pressures. In this sense, the judiciary and those who rely on this institution depend on other parties to act responsibly in sustaining and upholding a continuously fair, independent, impartial, and efficient justice system. Be it internal or external judicial independence, they are both inextricably intertwined with the notion of public confidence in the judiciary, and perhaps I can now move on to state my observations on that. Unlike politicians, judges do not and indeed cannot answer to or be governed by political will or popularity. A judge is meant to be an independent, constitutional arbiter of justice between the state and its subjects and vice versa, as well as between subjects inter se. His or her loyalties are apparent in a constitutionally ordained judicial oath taken to protect, preserve, and defend the federal constitution. Since judges do not answer to public opinion, popularity, or sentiments by virtue of them being appointed and not elected, judges then, in the truest sense, are accorded that independence to make decisions based solely on the facts and the law without any attendant fear of the political or social outcome of their decisions. This then begs the question, where does public confidence fit into this equation? What I can say is that public confidence and popularity, though related, do not mean the same thing. A judiciary that enjoys popularity would naturally command significant public confidence. In such a situation, popularity is merely the outcome of strong public confidence. In my view, public confidence in the judiciary is the measure and tool by which judges remain transparent and accountable to the public. Since we are appointed, the public whom we serve by authority of the Federal Constitution has no means of voting us out of office, so to speak. Public confidence in this sense means that the judiciary is mindful of the fact that it is the ultimate servant of the Federal Constitution for the benefit of the public. Because we are appointed, the basis of our foundation of our powers is trust and confidence in the process. It therefore continues to generate an impetus for judges to remain accountable and transparent, and this is obvious in our need to write judgments and to abide by case timelines. Perhaps it is pertinent to highlight that contrary to common belief, judges truly do not carry much in the form of direct power.